Hi, everyone. Thanks for coming out today and attending the first webinar in the HRSimple.com webinar series. My name is Eric. I'm from HR Simple, and we also have Lisa and Jeff from HR Simple on this webinar today as well. It looks like we have about 50 HR professionals right now on the line with us, so thank you for taking time out of your day to come learn with us. I want to thank Shawe Rosenthal, authoring firm of HRSimple.com's Maryland Human Resources Library, for providing our expert speakers today, Elizabeth Torphy, Donzella, and Teresa D. Teare. Elizabeth and Teresa, thanks for taking time to speak today, and we hope you're staying safe with all the craziness that's going on out in Baltimore right now. Okay, so here's today's agenda. We're going to give you a short introduction to our speakers. Then we'll just start in with the presentation from Elizabeth and Teresa. If we do okay on time, there should be a few minutes at the end to answer any questions you might have. Feel free to enter your questions in the chat box during the presentation. Okay, to get things started, I'm going to kick it over to Lisa to introduce our speakers.
Thanks, Eric. My name is Lisa. I also work at HRSimple.com with Eric. We have two really great speakers today, Teresa D. Teare and Elizabeth Torphy Donzella. Teresa D. Teare is a partner at Shawe Rosenthal who represents employers and management in labor and employment-related litigation. Teresa advises clients in virtually every facet of employment law, including implementation of policies, recruitment and selection of employees, hiring procedures, wage and hour compliance, and counseling and disciplinary actions. Teresa regularly provides training to management and employees on a variety of issues, including compliance with anti-discrimination and anti-harassment laws, the Family and Medical Leave Act, the Americans with Disabilities Act, and the Affordable Care Act. Active in the American and Maryland State Bar Associations, Teresa has been an adjunct professor at the University of Baltimore School of Law, where she taught courses in legal writing and advocacy. And our other speaker, Elizabeth Torphy Donzella, joined Shawe Rosenthal in 1995. Since then, Elizabeth has tried cases involving claims of sexual harassment, national origin discrimination, race discrimination, wage and hour, and wrongful discharge. Additionally, Elizabeth designs and conducts customized training sessions for managers and employees intended to foster behavior that will reduce the potential for employment-related claims. Elizabeth currently serves as General Counsel to the Maryland Chamber of Commerce and is a member of both its Board of Directors and Executive Committee. She has served as co-counsel for the United States Chamber of Commerce on several occasions and is a past management chair of the EEO subcommittee of the American Bar Association's litigation section.
Thanks, Lisa. Okay, Elizabeth and Teresa, you have the floor. Thanks again for joining us today.
So these are specifically the states that cover private employers. They include Hawaii, Illinois, Massachusetts, Minnesota, New Jersey, and Rhode Island. In addition, many localities have passed similar laws, and they include, because we're presenting from Maryland, I'm going to highlight the Maryland laws: Baltimore City, Montgomery County, Maryland, Prince George's County, Maryland, and close by to us, Washington, D.C. The ban-the-box laws basically dictate when you, as employers, can conduct background checks or can conduct, inquiries into criminal history of the applicants. I want to note that states have passed laws that cover government employees. For example, in early April this year, the Virginia governor signed an executive order banning the box on state employment applications and encouraging private employers and government contractors to do the same. In addition, last week, interest groups urged President Obama to ban the box for federal contractors. And why do I note this? Because this is something that is sweeping across the country and is gaining a lot of traction, not only to apply to private employers, but to government employees, and federal action may be anticipated on this. In addition, we've seen private employers on their own that may not be subject to these ban-the-box laws decide that they want to drop the criminal history questions from their applications. For example, I just saw last week a news article that said Koch Industries drops criminal history questions from its employment applications. And it wasn't subject to any specific law, but the company decided that it didn't want to ask criminal history questions on the job applications early on in the process. What are the ban-the-box laws? Well, they generally remove the criminal conviction history question, which is the box basically on the application, on job applications, and they delay the background check inquiry until later in the hiring process. So it's not that employers are completely banned from asking about criminal history. The question is, when can you do it in these certain states? And what is the public policy behind this? Well, the idea behind these laws is that individuals should be judged on their qualifications, their skills, abilities, training, education, and not solely disqualified immediately from any type of employment based on the fact that they have a criminal history. I'm going to go through some of the laws so that you can get an idea of what these laws actually mean and say. And I will be covering the local laws in Maryland, but I want to note that wherever you are, because I know that we have many participants on the call who may not be from Maryland, the bottom line is you have to figure out whether a law in your jurisdiction, in your state or your county, applies to how you conduct the criminal inquiry during the employment application process. Baltimore City passed a law that became effective August 13, 2014, so not quite a year ago. Baltimore City employers may no longer make an inquiry or examination into or require any disclosure of an applicant's criminal history before a conditional offer of employment has been made. So you'll see here, it's before a conditional offer of employment has been made. That's the critical piece here. The timing is critical as to when your entity or your organization as an employer can inquire into the criminal history of an applicant. And the laws differ in this fundamental aspect. In addition, you have to determine to what employers the laws apply. So in Baltimore City, the law applies to employers with 10 or more employees in Baltimore City. And it covers applicants applying for employment in Baltimore City. And this differs from other laws that I'll talk about later. So it covers applicants. Some other laws cover employees also. So when an employee applies internally for another position in the company, you cannot at that time potentially inquire into criminal background history. Now, all of the laws have exemptions. I'm going to highlight Baltimore City's exemption from the law is that it exempts any facility or employer that provides programs, services, or direct care to minors or vulnerable adults. The restriction also does not apply to any inquiry or other action that is required or expressly authorized by some other law. So, if there's another law that says, for example, a federal government agency may have employees in Baltimore City, and the federal agency requires background checks, they might be exempt if it's expressly authorized by some other law. Now, what are the damages? Employers always want to know what happens if we don't comply with this law. Well, in Baltimore City, for example, the potential damages range from back pay, assignment to the job applied for, compensatory damages for humiliation, embarrassment, emotional distress, and expenses incurred in seeking other employment, and attorney fees. Now, this is the most aggressive form of penalties that we've seen as compared to the other local statutes, at least at this point. In Montgomery County, which is a county outside of D.C. in Maryland, they also passed a ban the box law that became effective just a few months ago in January of 2015. I'm going to highlight the differences so that you can see how these laws differ from county to county, and how employers with multiple locations in different jurisdictions are going to have to figure out how to comply with the patchwork of laws that we are now seeing in this area. So in Montgomery County, an employer may not inquire about an applicant's criminal history until the end of the first employment interview. So again, the timing is critical here. You can compare this to the Baltimore City law, which we talked about, which you can't inquire until a conditional offer of employment has been made. Montgomery County only says that you have to wait until the end of the first employment interview. So what does this mean? Questions about criminal history cannot be made on employment applications. So again, the box cannot be on the employment application, but you don't have to wait until you're completely done the employment screening process and you have one candidate in mind to ask the question. You can do it at the end of the first interview. And just to compare the Baltimore City law to this law, Montgomery County applies to employers with 15 or more full-time employees in Montgomery County. As you recall, the Baltimore City one was 10. So these laws differ in their application and how they apply to how you conduct your criminal inquiries. The Montgomery County law applies not to just outside applicants, but also to current employees applying for new positions with the employer. This is, again, different than the Baltimore City law, which only applied to applicants. And there are similar exemptions to the Baltimore City law. So, for example, inquiries expressly authorized by federal, state, or other county law. If the police department, fire or rescue, Department of Corrections and Rehabilitation, they're exempt from the law. Employers that provide programs, services, or direct care to minors or vulnerable adults are also exempt from the law. In Montgomery County, the law requires notice to employees or applicants. So if an employer decides to withdraw an offer of employment because of criminal history, the applicant must be notified, provided with a copy of the criminal history report, and given 7 days to contest the accuracy of the report. And as many of you may know, and we'll get into a little bit later, the EEOC's guidance on this is similar, as well as the Fair Credit Reporting Act, that when you are making an adverse employment action based on criminal history, criminal convictions, you have to provide notice and a copy of the report. Interestingly here, if no offer of employment is made, so if you don't get to that point in the process, you don't have to provide notice. So you can imagine if at the end of the first interview or after the end of the first interview, you inquire or later inquire as to criminal history and the report comes back and you see that someone has been convicted of a felony that would disqualify them potentially for the position, and you haven't offered employment at that time, under the Montgomery County law, you don't need to provide the notice. But under, as my partner Liz will talk about a little bit later, that might be, the Fair Credit Reporting Act might dictate that you do provide some notice, so you need to be aware of that. Montgomery County's penalties are lower than what we saw under Baltimore City. So employers may be assessed penalties of up to $1,000 for violations, but damages are not available to individuals under the Montgomery County Code as written. Now, in Prince George's County, another county in Maryland, the law became effective January 1st of this year. The law is similar to Montgomery County law, but it states that employers that are considering disqualifying an applicant based on criminal history must make an individual assessment. And this is very similar to the EEOC's guidance, which I'm going to talk about a little bit later, that you have to consider the position they're applying for, consider the conviction, consider the time that's lapsed since the conviction, and any other mitigating factors. Now, Prince George's County, you see, applies to employers with 25 or more employees in Prince George's County. So all of these laws, differ again in what employers they apply to and how they dictate how you conduct these background and inquiries. The Prince George's County law has similar exemptions that we talked about before. So if you're an employer that provides programs or services or direct care to minors or vulnerable adults, or positions for which federal security clearance is required, you may be exempt from the law. Under the Prince George's County law, notice obligations are required, so you have to provide notice to the employee and 7 days to contest. Employees or applicants can file complaints with the county human rights offices, and we anticipate in Prince George's County regulations, which are going to be issued to enforce the law and to provide more guidance on the potential penalties. We don't know what they would be right now. And then my final example of a ban-the-box law that I want to highlight is the Washington, D.C. law. So this became effective last December 2014. So you can see all of these laws are relatively new within the last six months. The Washington, D.C. law applies to employers with 10 or more employees in D.C. that are not otherwise exempt. So again, you have to figure out whether there's an exemption that applies to your organization or to the position that you're recruiting for. And the D.C. law is very similar to the Baltimore City ban-the-box law in that it prohibits inquiring about or requiring an applicant to disclose a criminal conviction until after a conditional offer of employment is made. So you have to give the conditional offer to the applicant, and then you're entitled to do a background check on their criminal conviction history. Under the D.C. law, employers are not allowed to inquire about an arrest or a criminal accusation that is either not currently pending, so an arrest or a criminal accusation that's not pending right now that might come up on the criminal background check, but only shows as an arrest or an accusation or charges, or did not result in a conviction. So you can inquire about arrests under the D.C. law. Employers may only withdraw a conditional offer of employment if the employer has a legitimate business reason for doing so, and those are the words of the statute. So what's a legitimate reason for doing so? You have to take into consideration the duties of the position, the time elapsed since the conviction, the age of the individual at the time of the conviction, the frequency or seriousness of the offense, rehabilitation, and the applicant's conduct since the conviction. So any mitigating information that they might give you to show that they're fully, they have rehabilitated from any criminal convictions that they had in the past. Now in D.C., if a job offer is revoked or an adverse employment action is taken, the employers have to provide the applicant with a specific form that the DC Office of Human Rights released. And I have a copy in the next slide, but it's a notice of the right to file a complaint. So you have to give the employee this notice that an adverse employment action has been taken, and then that they have a right to file a complaint. Job applicants can request their interview and hire-related records, including any criminal background records obtained from the employer using a request for records form or any other method. So not only do you have to give them this notice of right to file a complaint, but if they ask, if you have an applicant that comes to you and says, I want all of my hiring-related records, you have to give that to them. And for your purposes, here is a copy. It's difficult to read, but you can find this online on the District of Columbia's website. This is the Criminal Background Screening and Employment Notice of Right to File a Complaint, which must be given if you take an adverse employment action against an employee in Washington, D.C. because of criminal conviction. And this is the request for record form. Now, does the request for record have to come on this form? The answer is no. It could come in a different format, but here is a sample one. And the potential penalties under the D.C. law range from $1,000 to $5,000 depending on the number of employees. So it's not as high, of course, as the Baltimore City one, but obviously we don't want to get into situations where you're subject to penalties. So what does this all mean? I've highlighted several laws for you. Again, in your respective jurisdictions, you're going to have to determine which state, if any, which county or city law applies to your organization. And then figure out, if you have to comply with those laws, how do you do that? So we need to look at the employment applications that you're currently using, and if there's a box for criminal conviction history or have you been subject to a criminal conviction, check the box. You have to take that off of those, the paper applications. You might want to black out the section on the paper applications containing questions about an applicant's criminal conviction. Obviously, you can revise your applications or order new applications as the case may be. In the online application process, the forms similarly must be modified to ensure that applicants do not submit information about criminal history during the application process. And so I know that's difficult for employers that have positions and facilities and locations potentially across the United States or multi-jurisdictional. So what do? You can consider including an opt-out question, and I have a sample one here. You'll have to tailor it to meet the needs of your organization. But, for example, having this opt-out question, are you applying for a position in, and list the states that, or the cities or the counties in which you can ask this question. And then if the answer is yes, the applicant should be excluded from any questions concerning criminal convictions. And, I don't know if you have to change your software, if you have applications online or whatnot, but you have to look into that. In addition, it's fundamental that you train the people who are involved in the hiring and interview process so that they know when in the process they're permitted to ask questions involving criminal convictions, because again, the timing is key to avoid compliance. And one more thing before I turn it over to, get into the EEOC guidance, I want to note that there's no absolute ban on the use of convictions. So you're not completely banned as employers from using criminal convictions in the hiring decisions. You can still make it clear on your employment applications that satisfying a job-appropriate criminal background check will be a condition of employment, but you must comply with the Fair Credit Reporting Act that Liz will talk about and the EEOC guidance. Okay, long before these ban-the-box laws came into effect, the EEOC, the Equal Employment Opportunity Commission, which I assume most of you know about, had guidance on arrest guidance on the use of arrests and criminal convictions in employment. And one of their key strategic strategies or enforcement plans in 2012 that they announced was eliminating hiring barriers in employment, including criminal conviction barriers to getting people out working. The EEOC takes the position that the use of criminal histories can have a disparate impact on minority groups, including African Americans and Hispanic applicants. In addition, disparate treatment claims can arise or have been the source of litigation. So what does the EEOC guidance say? Well, the EEOC takes the position that arrests do not establish that criminal conduct occurred, and that you can only exclude an employee based on an arrest if it's job-related and consistent with business necessity. I would tell you to tread very lightly when using any arrest, because as we talked about with regard to ban the box, simply being arrested for something doesn't mean that the person was guilty. And we don't know if the conduct underlying the arrest actually occurred or didn't occur. So you, as a general rule of thumb, you shouldn't use criminal arrest records as grounds for not hiring people. And I say tread lightly here and call counsel if you have questions. Now, with regard to convictions, the EEOC takes the position that convictions usually serve as sufficient evidence that the person engaged in the particular conduct, but the employer needs to apply an individual assessment to each applicant to determine whether the applicant is disqualified for the position. So what does that mean? You have to look at the nature and gravity of the offense or the conduct. So look at what the employee or applicant was convicted of. What is the crime? The time that has passed since the offense, conduct or completion of the sentence, and the nature of the job held or sought. So I give an example here, which I think highlights this. If an employee or an applicant was 15 years ago, when they were 18 years old, arrested for marijuana use, and they're now applying for a position as a secretary at a law firm, that criminal conviction for marijuana use probably isn't relevant or job-related, or shouldn't be a ban or bar to the person getting the job. Time has passed. You have to look at the age of the applicant at the time the crime occurred, the nature of the conviction, marijuana possession. It doesn't have to do with how she's going to potentially perform her job as a secretary in a law firm. If the employer intends to use a criminal conviction to bar employment, you must, as an employer, similar to the ban the box laws that require this notice, inform the individual that he may be excluded because of the past criminal conduct, provide the individual an opportunity to demonstrate that the exclusion does not properly apply to him, and consider whether the individual's additional information mitigates the criminal conviction. So the EEOC would want you to have a dialogue, some sort of discussion, whether it be in writing or verbally, with the applicant to determine whether to allow, for lack of a better term, him to tell his side of the story. Now, before I turn it over to Liz, a few things about the EEOC and their current litigation involving criminal conviction history. They're taking a very aggressive approach to employers' use of criminal conviction history. There's active litigation, some of which I've mentioned here, highlighted on the screen. But they have been dealt some blows in these litigations that they've been pursuing, and setbacks. And we're watching closely all of these cases. One in particular that I'm going to mention is this Fourth Circuit case. The EEOC, filed a lawsuit against this company, and they alleged that the criminal checks had a disparate impact on African American males. In order to prove that, they relied on expert evidence by some expert that they hired, and the evidence that they provided was full of errors and mistakes, etc. And so the case got kicked out on that because the government's reliance on this evidence was faulty. But they didn't the court never got to the heart of the matter, which is, does these criminal conviction policies have a disparate impact on African Americans? So again, we're waiting to get, court rulings on these cases, but it is a area of the law that you should be aware that the EEOC is actively pursuing. And with that, I'll turn it over to Liz.
Thank you, Teresa. Good afternoon, everyone. I hope everyone's had some coffee because I always find afternoon to be a little hard to stay awake. But we'll try to scintillate you with the Fair Credit Reporting Act here. Before I get to that, I think I'll mention one thing about what Teresa spoke about, and that is the ban-the-box laws that have been proliferating at the local level truly have been a burden for employers. And so what we're seeing is states passing ban-the-box laws statewide that also include preemption, such as in New Jersey. The New Jersey law applied a statewide ban-the-box rule and preempted the local laws. So for employers, that's far better. You don't have to deal with multiple jurisdictions. The other thing I'll say about these laws is in Prince George's and Montgomery County, Maryland, we saw human resource professional groups get out in numbers and engage the legislators in dialogue about the laws in order to ameliorate them and make them a little bit more manageable for employers. So, for example, in Montgomery County, they convinced the legislators there should not be damages to individuals because that would just encourage people to file applications so they could file claims. So, I mean, the moral of that story is, become involved as an employer because we're seeing a lot of employment legislation proposed by legislators that you as individuals within the HR community can do something about. So the Fair Credit Reporting Act, it's been a law that's been around for a long time, and you would think it would just apply to credit reports in the application for credit context. But no, it applies to employers, as you know, who use third parties to conduct employment-related background checks. It imposes very technical requirements, and it frequently results in violations because the technical requirements have to be followed slavishly. And the technical violations that we are seeing currently are leading to class action lawsuits against employers. So what was the congressional intent in passing this law and applying it to employment? The notion was an employee has the right to receive a simple and understandable notice and to consent before anyone looked at their background as a condition of employment. And it also felt that if an individual was going to be adversely affected by such a check, the person should have a right to know, so that if there was a mistake, and as you all know, those mistakes do happen, that the person could correct the record and perhaps get the job. It does not impose any obligation on an employer to forego a decision. It just requires you to wait and follow a few rules. That seems really simple, right? Wrong. Simple errors add up, as I said. What we're seeing in litigation, as well as in dialogue with our clients, is that the form that authorizes the report and provides the disclosures also includes other information. Somewhat obnoxious information in some instances, we'll talk about that, but the inclusion of other information leads to a lawsuit. The pre-adverse action notice requirement, I call it a two-step. First, you give pre-adverse action notice before you take the action, and then you take it. It's often missed as that first step. Or employment is denied or the offer is revoked without any pre-adverse action notice at all. And the problem with this law is you have a statute of limitations that can make you liable for claims from 2 to 5 years back. And that can involve, if you're a large employer, tens of thousands of violations. And if you're a small employer, it can involve, tens or 20s or hundreds. So what we're seeing is class action lawsuits. Individually small violations are cumulatively large, and so I think we've all heard about the Fair Labor Standards Act litigations and how there are boutique law firms that focus on that because small violations result in large attorney's fees, and that's exactly what's happening in the Fair Credit Reporting Act case. And frankly, these are easier cases to prove than FLSA, so you were seeing an uptick in them. And so this slide indicates this is leading to very high dollar value settlements as well. It's like throwing chum in the water when they're sharks. So what is a covered employment-related consumer report? It's any third-party conducted background check of an employee's or applicant's credit history, criminal history, or general reputation via records or interviews. And again, that's third party. So if you as the employer access the criminal records database on your own, you conduct your own checks, you are not engaging a third party, and so the Fair Credit Reporting Act does not apply. There are up to 3 required notices under the Fair Credit Reporting Act, and we'll talk about each. The first is the authorization form, and it has to be a standalone authorization and disclosure form that is consented to by the applicant prior to a check. And then there's what I said before is the 2-step, a pre-adverse action notice and an adverse action notice. So what is this authorization and disclosure about? It requires, and this is statutorily and by regulations, a clear and conspicuous written disclosure consisting solely, and I mean solely, of notice that a report will be procured and disclosure of the individual's rights to learn the nature and the scope of the investigation if they make a request. Nothing else. No releases, no blanks for Social Security numbers, no driver's license numbers collected. Courts are finding any additional information results in a violation because it's quote-unquote distracting the individual from the notice that they're supposed to be receiving. Now, frankly, asking for someone's Social Security number to me is not a big distraction, but let's not put ourselves in harm's way by taking a who cares position, right? And here is a legally compliant authorization form that we have prepared, and you will get this in your materials, but you will see it's 3 paragraphs. There's nothing there. There will be a signature line that is not on the form, but nothing else, just the notice and the authorization. And by the way, this is structured so that a consumer report is permitted in connection with hiring as well as promotion, reassignment, retention, et cetera, so that if during the course of an individual's employment you need to do some sort of background check again, you're able to do so without seeking a new disclosure. So what's this pre-adverse action business? What it means is if you receive a report on an individual that indicates that they may have an employment disqualifying background hit, before making or communicating a final decision, you have to advise them that the report may result in an adverse action, give them a copy of that report as well as their notice of rights, which is available on the website of the Consumer Financial Protection Bureau website, and then provide a quote-unquote reasonable period of time for the individual to correct or respond before making a decision. And here is a legally compliant pre-adverse action notice. But you will note that it's something that is supposed to be communicated before a decision is made. And what we're seeing in litigation is that plaintiffs' attorneys are probing whether or not the pre-adverse action notice was perfunctory. So evidence that the employer filled the position during the pre-adverse action notice period, or internal emails communicating, well, let's go through the dance here because we're not going to be able to hire this person. Don't do those things, because let's let them have their notion that we really aren't going to make a decision if someone has a murder conviction, right? So I get a little bit cynical about these things, as you can see. So the pre-adverse action pitfalls. There's a very recent case came out in February, Cox versus Teletech at Home, Inc. Had, as you would imagine by the name of that company, had an online application process where an individual was given a conditional offer subject to having a successful background check. And this person received an automatic email, however, after criminal history was found saying urgent rescinded offer. And it said, we've decided to revoke your offer, subject to successfully challenging the accuracy. Well, that's ambiguous. Have you revoked the offer, or is the offer not yet revoked? A copy of the report was also not provided. And frankly, during discovery, the company couldn't recall exactly who came up with this urgent rescind offer notice. They didn't even know it was going out. The bottom line was that the court denied summary judgment, which meant there will be a trial, because the court said a jury could find here that due to the unclear communications, there may have been a decision made before an opportunity to correct was provided. And so that illustrates the point. You want to be clear. You want to know what communications are going out on your behalf, and you want to stay in your lane and do exactly what you're supposed to under this law. If an adverse action is to be taken, after a reasonable period of time, you may make and communicate the decision, but again, you must provide information. When you make that revocation, and the reasonable period of time, by the way, is presumed to be 5 days, 5 business days. When you provide the decision, we're not hiring you. The name and address and telephone company of the reporting agency, a statement the reporting agency did not make the employment decision, a statement describing the person's rights to receive a free copy of the report if requested, and a statement that the individual must deal with the reporting agency directly to dispute the report. Obviously, you don't want them calling you. It's not your report that caused the decision to be made. So what are the damages for violations? Negligent violations, you should have known better, but you were doing the best you could. Actual damages and attorney's fees. Willful violations, larger damages. The greater of actual damages, greater of, or statutory damages, $100 to $1,000 per violation. That's per violation per person, plus punitive damages and attorney's fees. So, as I said at the start, these damages can add up. And in the Teletech at home case, the willful violation was established by the fact that the company was sending out notices for years without anyone knowing what was being communicated. So that's the example here. Reckless disregard of the statutory duty, that's the Supreme Court standard under the FCRA. That was issued in an insurance case, but it's applied to employment. They had no policy or procedure governing FCRA compliance. So court expects you to have a policy about how to take charge of and properly fulfill your obligations, at least within HR, right? There was a form email sent to applicants rescinding the offer for 2 years without anyone noticing, as I said, and very poor coordination with the third parties administering the FCRA notices. And I will tell you, this third-party administrator has been involved in 3 of the cases that I have seen reported recently. So the moral of that story is know what is being done on your behalf and don't assume that the vendor that you're hiring is necessarily doing it right. Even though they should know, it's your job to make sure they know because you're going to be liable. That's my first takeaway for claims avoidance. Look at the agreement that you also have with the vendor. Is there an indemnification if you're sued for their errors, or are you indemnifying them? Does the agreement limit their liability? It may, and you may not be able to negotiate that, but know it's in the agreement. Slavishly follow the rules on the content of notices. Do not collect information, and do not think the form that the background check gives you to collect information is compliant to avoid any obligations on your part. Review all of the writing used during the application process for legal compliance. Again, don't rely on the background check firm to do your job for you, or if they're going to do your job for you, make sure you know what they're doing on your behalf. Adopt written policies and procedures that those involved in hiring are aware of so that they do not violate the law and you're not seen to be willfully failing to discharge your duties. And train, as we always say, train everyone involved so that they know what has to be done to do the job right. And frankly, you don't need a lawyer to train people to do the job right here. You just have to sit down with your team and walk through these forms and explain the process. We're happy to do the training, but you can certainly do this one yourself. More keys to claim avoidance. Where conditional offers are made, avoid beginning the onboarding process before receiving the background check results. And if efficiencies demand otherwise, really be careful in how you handle a pre-adverse action step. I talked to somebody yesterday. They said, it was another attorney said my client is onboarding employees because they need bodies now, and, how do we handle this? And I said, well, the problem is, if you have someone who has started and you have to revoke the offer, you're pretty much in the position of having to put them on paid leave before you tell them that they cannot work there any longer. So just be aware that, putting someone on unpaid leave would be an adverse action. So think very carefully about onboarding and having people start before the process is complete. And if the background check results are employment disqualified, as I said, do not communicate or make an adverse action before the end of the pre-adverse action notice period. you may know that if the person can't clear it up, and they probably can't, they're not going to be hired, but keep that in your head and not written on a piece of paper. So that's the end of the FCRA, but that's not the end of restrictions on the use of credit inquiries in employment because, as I said, the FCRA is agnostic on whether or not a credit check bars someone from hiring. It's really looking at process and making sure process is followed. Credit laws that are being passed in states go beyond process and look at when you can and cannot use the reports. And what's the background of this? And as we all remember way too painfully and too recently, the financial crisis of 2008 really decimated a lot of people's credit. People had lost their houses as if they were underwater, they couldn't pay their bills, and many people, as a result, have suffered poor credit scores. So the agencies and legislators step in. The EEOC tries to use the theory of adverse impact that Teresa talked about in connection with criminal histories to try to regulate the employer use of credit history, although that's not been particularly successful because bad credit is often shared by people regardless of race, and what the EEOC is regulating is race discrimination, not bad things that happen in the workforce. So they've had limited success. A federal bill sponsored by Elizabeth Warren that would drastically prevent or limit how credit can be used in employment is right now dead. I think it looks like it will remain that way, but it is a very difficult and strict bill. So in the absence of the federal government being able to legislate, as has been common, the state legislators are stepping in and acting to limit employer use. And here is a list of the states that currently limit employer use of credit. The EEOC's disparate impact cases, there was one against Freeman and Kaplan for alleged discrimination, the use of credit in employment based on race. As Teresa indicated, the same shoddy statistical proof was used in each case, and so we don't know what the courts will think of an adverse impact case that's proven by evidence that gets through beyond the shoddy. So state laws, what did they do? We're going to talk about Maryland in particular, but generally speaking, they broadly limit the consideration of credit in employment and then identify exceptions because there is a recognition that credit is a relevant inquiry for some jobs. Typically, access to money in a retail transaction is not a valid reason for a credit check under any of these laws. So the fact that somebody runs the cash register, the fact that they take a customer's credit card in a restaurant and ring it up, even though there's potential for fraud, credit is not seen as a valid reason to deny someone's employment on that basis or check their credit. However, access to large sums of money, like $10,000 in California or $2,500 in Connecticut or Illinois, that's seen as enough to merit using a credit check. And also, access to confidential or trade secret information is, under many of these laws, also a valid reason. So, as Teresa said, the moral of the story is you need to know your state law. In Maryland, it's called the Job Applicant Fairness Act, and we always name laws in positive terms when we want to regulate something and make it look like we're not being restrictive and regulatory. So the Job Applicant Fairness Act in Maryland was passed and became effective in October of 2011. It was patterned on the Illinois statute, and it regulates the use of credit in decisions to deny employment, discharge an employee, or determine an employee's compensation or terms and conditions of employment. So essentially, it limits the use of credit from the start of the employment to the end. It does, however, the law exempts, as I said, employers from the law based upon what the legislator has determined to be legitimate criteria. So if you're required by federal and state law, to inquire about an individual's credit history, you may do so. If you are financial institutions that accept deposits that are insured by a federal agency, et cetera, you also may do a credit check. Credit unions that are governed by the Maryland Commissioner of Financial Regulation may do them as well. And entities or affiliates that are registered as investment advisors with the SEC are required to do reports or inquiries into an applicant's credit history may do such checks, and you can understand why a financial advisor who has access to a multitude of information of a private nature about individuals, you would need to do a credit check. But all other employees, credit history may only be obtained in Maryland after a conditional offer of employment is made and provided that, one, the employer has a bona fide purpose for requesting or using the information in the credit report or history, and the purpose is substantially job-related and disclosed in writing to the employee. That's a mouthful, isn't it? The statute itself identifies non-exclusive list of positions with bona fide purposes. And what that means is the statute is going to give you some safe harbors as to what would be a bona fide purpose, but that does not foreclose you from articulating another bona fide purpose for a credit report subject to an individual's right to sue you in court and litigate whether or not that's really bona fide. So the ones that the statute lists, and I won't read each of these because you'll be able to see it, but essentially, management jobs that involve determining the direction or control of the business. That sounds like the executive or administrative exemption, right? Positions that have access to personal information of a customer, employee, or employer. So you can imagine if you work in an HR office and you have access to Social Security number, driver's license number, that's going to be a bona fide purpose. But as I said before, retail transaction information to which employees have access, it's stated to be not a bona fide purpose, so you can't litigate that one, not successfully anyway. Third, jobs with a fiduciary duty to the employer. Fourth, positions in which the incumbents are provided with a credit card or a debit card or an expense account, so people who have the privilege of having access to funds. People who have access to trade secrets, and positions that have access to confidential business information. All of those are bona fide purpose positions. So enforcement of the law is always important. How is this law enforced? Because this is how you can be sued and how you can be fined. Under this law, the Commissioner of Labor of Maryland receives complaints. If there's a violation, the Commissioner attempts to resolve complaints. And if there's no resolution, there are fines of $500 for the first violation and up to $2,500 for repeat violations. And if the employer does not pay, then after a violation is found, the civil action may be brought by the commissioner or complainant to enforce it. And I will tell you, as one of the individuals who worked on the Maryland Chamber's task force on employment laws to get changes to the law, these are some of the changes that we push for, though having there be a long process and deliberative process before an employer could be sued. In Maryland, we were not successful in foreclosing a lawsuit at all, but again, the moral of the story is involvement by the business community can at least ameliorate bad laws, if not prevent them. And I think, as I said at the outset, there are other states with credit check laws. Time does not permit us to speak about them all, but here is a chart for you so that if you're in one of those jurisdictions, you can go ahead and talk to your lawyer about the laws, or if you don't have legal counsel, do a little research on your own. I'm going to turn it back over to Teresa to conclude with social media and employment decisions. Teresa?
Thank you, Liz. Yes. Okay, with our last few minutes, I'm going to touch on, as Liz said, social media and using social media in your employment decisions. So we've talked a lot about the red tape that prevents you from looking into criminal conviction and credit histories. You might say to yourself, well, maybe I just want to Google the applicant, or maybe I'll ask them for their password to Facebook or their social media site so I can get all the information I need about them. Well, there are laws that govern this. Specifically, in the past 3 years, social media password protection laws have been sweeping across the country. They've gone from a privacy advocate stream to an employer's nightmare. In 2012, Maryland became the first state to pass a password protection law, and other states have followed suit, including the ones listed on the screen here, and one of which is not listed is Virginia, which just passed a password protection law about 2 weeks ago. So what do these password protection laws say? Generally, they prohibit requiring or requesting an employee or applicant to disclose or provide usernames and passwords and prevent end runs around the prohibition. So, for example, asking an employee to access a personal social media account in the presence of an employer, so called shoulder surfing. So you go behind the employee who's sitting at his desk and say, pull up your Facebook account, I want to look at your, who you're friends with and what you've been posting. It's prohibited under these password protection laws generally. As a sample one I want to highlight, Maryland's law. Under the Maryland law, an employer may not request or require that an employee or applicant disclose any username, password, or other means for accessing a personal account or service through an electronic communication device. And you cannot discharge, discipline, or otherwise penalize an employee for refusing to disclose the information, or fail to hire any applicant for refusing to disclose the information. But I want to note that under Maryland law, an employer can require an employee to disclose any username or password for non-personal, obviously company-related accounts that provide access to an employer's information systems or computers. And laws specifically state that employees may not make unauthorized downloads of an employer's proprietary information or financial information to an employee's personal account. So this can't be a shield for employees to download or take employers' information. These password protection laws, the takeaway here is that they really vary from state to state. But the general suggestions for compliance is you shouldn't be seeking access to private portions of an applicant's or employee's social media page. And you should prohibit in writing employees from using their own personal email accounts for business-related reasons. And not only is that because of the privacy considerations, but consider recently the Hillary Clinton controversy, which now she's used private emails and servers to conduct work-related business, and how the question remains how and to what extent the government can request that information back. In addition, don't try to circumvent the laws by using creative means for accessing social media accounts. For example, asking another employee to friend the applicant or employee on Facebook so that you can see what's on the posting. In addition, you should tread lightly when you're thinking about Googling or not Googling an applicant. Even if no state bans Googling, per se, consider the risk of accessing information that's out there. You may gain information about the applicant's protected characteristics or class, which may give rise to discrimination claims. And with that, right at 3 o'clock, we are finished our presentation. I think we're going to take a few of the questions that have been typed in. And the first one I see is, after you make a contingent job offer, can you legally ask what we, as the employer, would find on the applicant's background check? Liz, do you want to field that?
Well, I mean, my good friend Betty asked that question, and I think you wouldn't be conducting a third-party background check, so the Fair Credit Reporting Act would not apply. And if you're making a post-offer condition, you've made a conditional offer, you certainly can make that. I think you're probably charged with using the information that you're provided, even in a non-formal context, correctly consistent with the laws. Do you have any different thoughts, Teresa?
No, I agree that if it's after the conditional offer has been made, you are asking basically to the employee to disclose information truthfully about what you would find, so that if you conduct the background check, you're not surprised. So I don't see any problem with that. But again, you'd have to figure out the timing in the process to make sure you're complying with any state or local laws that might prohibit you doing it earlier than a conditional offer of employment.
Yeah, and that's really the bottom line. You really have to know the jurisdictions in which you operate and know their laws, because we unfortunately have a patchwork system, at least in Maryland and many other states. Well, it looks as if we do not have any other questions, so I guess we have been clear. It's been a pleasure presenting to everyone. And Teresa, do you have anything further you want to add?
No, thank you all.
I just want to say thank you to both of you for coming on today and talking. It was very informative. Thank you to all of our attendees for coming out. I hope you all got a lot out of this. On behalf.
Before they jump off, I just saw another question. I think it's a good one,
Okay.
so let's take it before we jump off. Just to clarify, is the question if we're using an online system run by a company, but we are not the ones typing in the employee information to initiate the search, the company is not a third party? I think the answer to that would be no. Any third party to you, any third party to your company that you are using to perform the service of a background check is a third party, even if for employment purposes, quite frankly, someone may try to sue you both as joint employers under a legal theory, but technically they're a third party. Do you have any difference of opinion, Teresa?
No, I agree.
And let's see, another question is, would that be used against me for a negligent hire case if I do something a customer wants to sue for? So that's a very good point, and that's something that we've said to legislators when they're limiting the use of criminal history. You're putting us with a Hobson's choice. You're requiring me to hire somebody, but you are foreclosing me from considering job-related convictions. And I think the answer they always come back with, and it's somewhat true, is number one, if it's job-related, you can refrain from hiring someone. But the second point is that if you're required under the law to hire an individual or to not consider certain convictions, then you're quote-unquote not negligent. So doesn't make you feel better if they hurt your customers or your employees, obviously, frankly, and that's the kind of bottom line. But that said, from a strictly legal perspective, you have not been you have not been negligent. Okay, Eric, you can close it out now.
Is there a question from Joe that you could take?
I think that was Joe's question.
Oh, okay, great.
Yeah.
All right,
So
wanted to make sure we got him.
Yep.
All right, great. Well, on behalf of HRSimple.com and Shawe Rosenthal, thank you everyone for spending time with us today. We hope you'll continue learning with us throughout the HRSimple.com webinar series. So thank you, everyone. Have a great day.